Good morning, Your Honour. My name is Katie Egerton, appearing today on behalf of the applicant, Mr. Otto Lowtower. Mr. Lowtower has been charged with possession of more than 200 grams of MDMA pursuant to Section 9, subsection 1 of the Drugs Misuse Act. Today, the defence is seeking a pre-trial ruling pursuant to Section 590, capital A, subsection 2E of the Criminal Code to have all evidence obtained from the vehicle stop be found inadmissible on the grounds of the exclusion discretion of public policy. Your Honour, before I begin, the offence took place in Queensland and therefore Queensland legislation is applicable pursuant to Section 79 of the Judiciary Act. Now, Your Honour, the fact in issue for this case is whether Mr. Lowtower had possession of the MDMA. The defence admits that all evidence recovered in the vehicle stop be inadmissible on the grounds that Senior Constable Targian failed to comply with the relevant provisions in the Police Powers and Responsibilities Act. This is in relation to Senior Constable Targian's unlawful exercise of power, not only when he stopped the vehicle to carry out a licence check in accordance with Section 60 of the Police Powers and Responsibilities Act, but also when he searched the vehicle. Further, Senior Constable's conduct and the circumstances in which the evidence was obtained may be found unlawful. This is evident from Senior Constable Targian's actions, which have breached Section 31 and subsection 32 of the Police Powers and Responsibilities Act when he stopped and searched the vehicle without a warrant, as well as the reason for the stop not falling within any of the prescribed circumstances for searching a vehicle without a warrant. Now, Your Honour, Section 32, subsection C does allow a police officer to search a vehicle without a warrant in the circumstances where an unlawful, dangerous drug may be present. However, this is not applicable as Senior Constable Targian had no reason to suspect of the possession of any drugs at the time of the stop. Because of this, it would be both unjust and unfair to admit such evidence. The other circumstances which led Senior Constable Targian to stopping the vehicle include recognising the passenger, Crispin Cole, and identifying where the vehicle was registered, both of which are not sufficient circumstances under Section 32 of the Police Powers and Responsibilities Act to search the vehicle without a warrant. This therefore demonstrates that the vehicle was stopped and subsequently searched unlawfully, and so any evidence found within this unlawful search must not be admitted. Your Honour, in the case of the Crown and Ireland, the court found that any evidence may be excluded if it was unlawfully, unfairly, or improperly obtained. This is further highlighted in the more recent case of the Crown and Dane Annor, where the police found illicit substances after searching a unit. This evidence was excluded in court due to the police failing to have a search warrant. Not only that, but it was also excluded in the public's best interest as the protection of an individual from unfair treatment should prevail. This case, Your Honour, of the Crown and Dane Annor, while occurred in a different location, maintains similar facts of searching a location without a warrant and finding illicit substances. It also then provides an example of finding evidence through a warrantless search, which led to all evidence becoming inadmissible due to its unlawfulness. Your Honour, as discussed, not only is it unlawful to admit this evidence, it is also in the public's best interest to then denounce the actions of the police to ensure that police refrain from abusing their powers and working outside of the scope of their powers. This then allows the public to maintain their faith in the police system and the judicial system. The gravity of the charge should be weighed against the gravity of the precedent that will be set if officers are not condoned for working outside of their prescribed powers when attempting to find evidence and make a prosecution, all of which was seen by Senior Constable Targian. The charge of possession of a dangerous drug is up to 25 years imprisonment pursuant to Section 9, subsection 1A of the Drugs Misuse Act. It would be gravely unjust to prosecute my client for possession of a dangerous drug where Senior Constable Tuggian obtained it illegally. In conclusion, in pursuit of procedural fairness, I ask that Your Honour seek a pre-trial ruling to seek all evidence from the vehicle stop be inadmissible, as it is clear the evidence was not found lawfully, and it is also in the public's best interest to ensure the actions of the police uphold the law, and are therefore held accountable for their actions. Your Honour, this concludes my submission for the defence. Thank you.